Good afternoon, Mr. Friedman. How are you?
Hi, Your Honor. How are you?
I'm doing fine, thank you. Okay, we're here on an application for a temporary restraining order on cause number DC 22-10503, total ancillary management plaintiff versus Timothy Paul Havens. Is that correct?
Yes, Your Honor.
Okay, I've read your petition and I've read your application, so tell me what's going on with this case.
Thank you, Your Honor. May I proceed?
Sure, go ahead.
And I appreciate that you've already read everything, so I won't fully regurgitate it. But to summarize where we are, the defendant was employed by the plaintiff as an IT administrator from September 27th, 2021 through last Wednesday, which was August 24th, 2020. Sometime on August 24th, Human Resources was notified that the defendant had been intoxicated at work and began threatening coworkers. And apparently, the defendant walked in between two coworkers and was aggressive, like, hey, what's going on here? And had a gun on his side or holster, however you want to call it. And that was very concerning to people there. The defendant also started unplugging computers and electronics at one of the co-workers' desks. So the plaintiff put him on suspension while they investigated his situation about drinking and the violence and whatnot. And then the defendant resigned. However, my clients are concerned for their safety and due to the unpredictability of the defendant and not sure of his state of mind considering his current course of action. So we are simply asking for a temporary restraining order to put this guy on notice not to come near the office and near these people in any way. And to us, there's no need for him to be there or be interacting with these people. We've also reported his actions to the police. And that's all I have, Your Honor. I'll show you what.
Okay, first of all, looks like his name is Paul Havens, is that correct?
Yes, Your Honor.
And was he given notice of this hearing today?
Yes, he was, Your Honor. I can.
Okay, and how was that notice given? You can just tell me.
I believe it was via email.
Okay, do you know if he was sent email notice of this hearing?
If you give me 1 minute, I can check. Miss Kingston's mother died, so I was covering this for her.
Okay.
So if you give me just a second, I will check really quickly. Your Honor, if I may, I spoke to Miss Kingston's assistant. She said that they sent it to him via email, and they also sent it to him through Texas e-file on the e-serve.
Okay. Let me ask you a couple of questions. Has this gentleman been back to the location there, to the place of employer's location since the 24th incident?
That I don't know, Your Honor. I can't.
Okay,
Can't speak to that.
I expressed some concerns with Ms. Kingston when she filed this last week, and we had some email exchanges, and my first concern was this cause of action that was being pled in your petition. It pleads a cause of action for threat of bodily harm, and it took me a while to kind of determine if that's an actionable cause of action based upon the circumstances. But giving you guys the benefit of the doubt, I decided to hear this. But I think one of the issues that you've got is that this seems to be a cause of action for Mr. Gardner, and I don't think the company has standing to plead a threat of bodily harm cause of action. And I wanted to discuss that with Ms. Kingston today, but in order to err on the side of safety, of caution, I'm going to issue this TRO today. I think when we come back for the temporary injunction, we need to clarify exactly who the plaintiff in this matter, because I don't think your company has standing to bring a cause of action for a threat of bodily harm. You understand what I'm saying?
Yes, Your Honor.
Okay, so, and you may want to bring this to Ms. Kingston's attention, but I am going to issue the temporary injunction. I've looked at the proposed order that you submitted, and I think it's somewhat broad. And I want to kind of narrow it. First of all, doing any act that is a threat that it reasonably places TAM or its employees or anyone else on its premises in fear of imminent physical harm, bodily injury, or assault. That's kind of broad. And I'm not going to include that in the temporary restraining order. B, communicating a threat to or through a person to TMA or its employees or anyone else on its premises. I will consider that in the TRO. C is doing any act that is intended to result in physical harm, bodily injury, or assault against TAM or its employees or anyone else on its premises. Again, I think that's somewhat broad, and I'm not going to include that in the TRO. D, engaging in conduct directed specifically toward TAM that is reasonably likely to harass, annoy, alarm, abuse, torment, or embarrass TAM or its employees or anyone else on its premises. Again, I think this is somewhat broad. And the reason I'm doing this, Mr. Friedman, is that unless the TRO is specific in nature as far as the conduct, it's kind of hard to restrain a person, and it's kind of hard to determine if they violated those restrictions. So I'm not going to include D.
If I may address that, Your Honor.
Let me finish first, okay? E, engaging in any conduct intended to damage the property of TIM or its employees. I'm going to include that in the temporary restraining order. F, going to or near place of employment or business of TAM. TAM requests the court to specifically prohibit defendant from going to or within 1,000 feet of TAM's office located at 3151 Halifax Street, Texas 75247. I will include that in the order. And G, interfering with TAM's use of business property located at 3151 Halifax Street, Dallas, Texas 75247. I will include that in the order. Now go ahead, you were about to say something?
Yes, Your Honor, and I apologize for interrupting you. So, generally speaking, for example, when we were saying doing anything that's intended to result in physical harm, bodily injury, or assault, that is, and I know this isn't a family law case, but that language is a typical. That's typical in a family violence case when you're saying, hey, don't come near the other spouse, right? Threatening physical violence. So I think that's why she pled it that way, because obviously I can't say, well, go through everything going, hey, don't come to the office with your gun, right, and threaten everybody.
Well, the
Right.
order is going to include that he is restricted from coming within, what do you say, 1,000 feet? 1,000 feet of the office. So I don't see how he can inflict any bodily harm on anyone if he can't even come within 1,000 feet of the office. I can do that. That's very specific, and we know if someone violates that. The problem I've got with these other requests is that they're so broad in nature that it would be difficult to determine sometimes if someone has violated that. So
All right. It is, as you said, it's to protect my client's employees
I
and
understand.
as well as for their peace of mind.
I
If they
understand,
think
Mr.
this guy
Freeman,
can
but-
come in,
I understand, but listen to me. If he can't come within 1,000 feet of the building, if the TRO says you cannot come within 1,000 feet, then obviously he can't do anyone any bodily harm if he can't come up on the premises. Now, I can't restrict him from wherever he wants to go. You know, if he runs across this Mr. Gardner in the Safeway, I can't keep him from going into the Safeway. So to say that he can't have any interaction with that person, I can't do that.
and we didn't ask that.
I
We didn't ask
understand that.
If he stands 1,000 feet away with a shotgun that has a range of 150 yards, okay, he's going to go, well, that's within the order.
Yeah.
That's a
Well,
threat.
that's my ruling, and you can mention to Ms. Kingston that I think first of all there's an issue with standing for your company to have this order. I don't see how a company can have a threat of bodily harm. Okay, that cause of action is limited to a person, and until I get some more case law that shows that a company can have a standing to present a cause of action, a threat of a bodily harm, I'm not going to rule that way. But I am going to issue the TRO and indicate to her that we're going to have a conversation when we look at the temporary injunction on whether or not there exists standing for the company to do that. And like I said in the beginning, I'm doing this on the side of caution. But I will initiate the TRO to restrain this individual from coming close to the place of business and from interfering with the property. And I think I said from communicating. I can do those three things. Okay, I can't restrain him from any act that is a threat that reasonably places TAM or its employees, anyone else on the premises in fear of imminent physical body injury or assault, because that's too broad. Okay, and if it's too broad, there's no way to distinguish if the restraining order has been violated or not. Now, if she wants me to reconsider this, I will do that. But like I said, I've got some concerns about it, and I expressed those to her before when I read the petition the first time. But I will generate that order, and this order should be available for you to retrieve it sometime today. I'm going to cross through item A, item C, item D. And I will include E, F, and G. And I will sign that and date it today and the time, and it should be available for you to get that sometimes within the next hour. And you need to make sure that you present that or give that to the defendant, okay?
Your Honor, are you going to require a bond?
Yes. I have to have a bond. Without a bond, the TRO is not valid. So I'm going to ask that you post a $100 bond. That's insignificant because I don't see how the defendant is going to be financially incapacitated with this particular TRO. So I'm going to include a $100 bond.
Thank you, Your Honor. I appreciate your time.
Anything further?
No, Your Honor. May I be excused?
You may be excused, and this should be available to you in give me about 30 minutes, okay?
Thank you very much, Your Honor.
Thank you.